Good afternoon, everyone. Thank you to all the participants who have gathered here today for this webinar on route to competitive neutrality, enhancing international trade opportunities for Malaysia. My name is Julia American, and I'm a senior research executive at the Institute for Democracy and Economic Affairs, or IDEAS. I'm honored to be your MC for this webinar today. So before we begin, please allow me to begin with just a short housekeeping announcement. At IDEAS, we're committed to providing a safe environment for all parties, both internal and external, to work together. We have a policy of zero tolerance towards sexual exploitation and abuse. So everyone here today is responsible for making this event a safe space for public discourse. Secondly, please field all of your questions throughout the event to our Q&A box. This is just the Q&A box, not the chat box. And you're free to do this throughout the whole session. I will read out the questions after the speaker presentations during our Q&A session. We aim to acknowledge and answer everyone's questions within our allotted time. But if you don't put them in the Q&A box, then we will probably miss them. So not in the chat box, in the Q&A box, please. And lastly, the information contained in these slides that our speakers will be presenting is confidential, privileged, and only for the information of the intended recipients. So please don't use them, publish them, or redistribute them without the prior consent of anyone from the organization. So with that, to officially begin our event today, I would like to warmly invite Ms. Jennifer Lopez, CEO of the British Malaysian Chamber of Commerce, to give her welcoming remarks. Over to you, Ms. Jennifer Lopez.
Thank you, Julia. A very good afternoon to everyone, especially Mr. David Wallace, the Deputy British High Commissioner to Malaysia, Ms. Dr. Trisha Yeo, and Dr. Juita, from IDEAS, Mr. Raj from Partners from Zaid Ibrahim and Co, and to all our participants. And good morning to those of you who are logging in from the UK. A warm welcome, everyone. So firstly, I would like to take this opportunity to commend the bilateral diplomacy team from the British High Commission Kuala Lumpur for taking the initiative to commission IDEAS on a study on Malaysia's competitive landscape. It is its regulatory limitations and challenges and uncovering the route towards competitive neutrality. So, ladies and gentlemen, I think it's very imperative that we create and promote a healthy competitive landscape for businesses in Malaysia. And healthy competitive landscape is fundamental for a well-functioning economy. Basic economic theories demonstrate that healthy competitive leads to lower prices, higher quality goods and services, greater variety, and more importantly, innovation, indirectly creating opportunities for talent development and attraction. So these are qualities that are attractive to every economy and nation. A fair playing ground and friendly business environment is essential investment and growth, and this will position well for Malaysia to be an attractive trade destination, especially one that will be interest of the UK businesses. Just to share with you, total trade in goods and services between UK and Malaysia currently stands at £5.9 billion. So it's wonderful to see the increase of about 13% from the last quarter. Very encouraging growth, and we at the Chamber, we look forward to keeping these numbers growing and the momentum going. So ladies and gentlemen, studies like this just don't stop here. We at the BMCC understand the importance of pushing the boundaries for Malaysia to retain its existing investors while being competitive and attractive to new businesses to come into Malaysia. So therefore, we will continue working with key stakeholders to promote trade, to our colleagues at Department with governments of both nations to promote trade, to strengthen trade between the both countries, to build a strong network of members, businesses, and to create visibility. Advocating and strengthening of trade is the Chamber's mandate. We believe that international trade can make businesses, make every business go stronger. And this year, we are proud at the BMCC, we are celebrating our 60th anniversary. So for the past 6 decades, we have been facilitating and promoting trade relations between the UK and Malaysia. And we are proud to be given the opportunity to be part of this precious relationship between the two nations. Today's webinar on Enroute to competitive neutrality, we are delighted to be part of this initiative. As I mentioned, how important this agenda is to raise the confidence of UK businesses, and not just UK businesses, but international businesses for the Malaysian market. So with this, thank you to colleagues from the bilateral diplomacy team, especially Adeline, who has approached us to work together, as well as the ideas team for partnering us. So with that, we hope that the webinar will share information for you to gain your confidence in Malaysia to venture into our market. So without further ado, I wish everyone a fruitful webinar, and I hope the discussion will inspire business opportunities between Malaysia and the UK. Thank you. Have a good afternoon, good evening, and good day to those in the UK. Julia, over to you.
Thank you so much, Ms. Lopez, for your warm welcome. I would now like to invite Mr. David Wallace, Deputy British High Commissioner, to provide an introduction to today's event. Over to you, Mr. Wallace.
Thank you, Julia. And first, a big thank you to Jennifer for all that you've said just now, and to the BMCC team who've put this event on. Thank you very much. And to, of course, Ideas for the project that you've done, which we're presenting findings on today. British High Commission is very pleased to be involved with the event and with the report onto our topic that is of real value and importance for the Malaysian economy. It really matters a lot to what the British High Commission is trying to do in Malaysia, which is to really build a modern partnership between the UK and Malaysia, one that allows trade to flourish between our two countries as well. So I'm really looking forward to hearing the presentations from Dr. Juita and from Mr. Raj as well on this. So the first time I was involved in any competition policy was when I was posted to South Korea too long ago to say how long that was. But we were trying to, at the time, work with the South Koreans on efforts that they were taking to try to loosen the grip of the chaebol a little bit in the market there. And this was something which British business was asking to be done and was pursuing. So we had competition policy advisors come out to to Korea to do that. But the competition advisor that came was surprised sometimes that the British businesses were asking for this. He said, because these are the same British businesses that back home are complaining a bit about the competition authority doing a bit too much. But I think, what the point he was making, of course, is that actually it's important to actually put policies in place that help markets, not necessarily individual businesses, but which help competition and therefore the companies that are engaged in that and doing good work to perform well. It's something which I think governments are looking to do when they're introducing competition policy. Might not always be comfortable for individual businesses, but it creates a better platform for the businesses as a whole. So these are topics, I think, which modern economies need to grapple with, and which the Malaysian economy is definitely working on. Malaysia is an open economy. It's one where its trading relations really matter to its economic growth, and therefore getting competition policy right makes a big difference. And it's doing pretty well. We'll hear more about it, I'm sure, but it's still in its infancy. It's still UK had its first competition regulations, I think, in the 1950s, and Malaysia only had its first in 2010. So it's still in the infancy of this, and has come quite a long way in that short space of time. What I think we can see as well from the UK's engagement, we had a representative from our competition authorities digital market unit here in January, having conversations with Malaysia Competition Commission, and were impressed by the commitment they had to learn from others and to develop plans for future regulations. So I think this is something which we can be quite positive about. However, I think we will hear, suspect we'll hear some of the challenges that remain for those authorities as they try to work with the government on implementing a modern competition policy, and looking forward to hearing about that from these presentations. So I think we can agree that if the Malaysian government and authorities get competition policy right, this is going to improve opportunities for trade. It's going to encourage innovation in the best businesses, and it's going to increase choice, quality, and price for consumers. And I think that's all things that we can all get behind. So thank you everyone for joining this. Thanks BMCC again for organizing and ideas for the intellectual stimulus that you're going to give us. Thank you.
Thank you so much, Mr. David Wallace, for your comprehensive introduction to today's event. I would now like to invite, without further ado, our first speaker, Dr. Juita Mohamad, who is the Director of Research at the Institute for Democracy and Economic Affairs, to give her presentation on the Competition Act and IDEA's regulatory review findings. Over to you, Dr. Juita.
Thank you so much, Julia, and I would like to warmly welcome our audiences from Malaysia, from the UK, and elsewhere as well. I will be presenting our findings, but the topic in itself is on competitive neutrality and how the competition ecosystem on the ground provides enhancing measures to attract international trade opportunities within Malaysia. Julia has kindly reminded us all that these slides are confidential and not for circulation, but we will be also working on standalone papers on selected subsectors, and we look forward to publishing it for public consumption this year onwards. So in Malaysia, the term government-linked companies is collectively and also liberally used when we refer to the vast ensemble of government incorporated institutions that are intertwined through complex ownership and also control patterns. So these variety of institutions would include government-linked investment companies, that has huge investments, and also saving-based institutions and sovereign wealth funds. And this also would include development financial institutions, statutory bodies, special vehicles, foundations, trust agencies, holding companies, and also various quoted and also unquoted enterprises with a presence in every economic sector within Malaysia. So while we see that GLCs are expected by the government to compete and to serve its purpose in providing non-profit or not-for-profit products, especially like in the agricultural sector, they're also tasked to execute and also assist the government's long-standing goal of nurturing Bumiputra companies. So here, the objective of our study is to examine the impact of interactions between different stakeholders, such as the state, the regulators, the GLCs or the SOEs, and private firms on competition across selected sectors within our economy. So we are also from the challenges that we see from the competition ecosystem that we see on the ground, we also offered policy recommendations to address these challenges so that we can promote healthy competition and competitive neutrality in Malaysia, which is very important to attract FDIs into the country. So the scope of our work would be, again, looking at the interactions between different stakeholders within the banking sector, the telecommunication sector, the energy sector, the higher education sector, as well as the ICT and fintech sectors. So to understand the challenges of regulating competition and also to nurture competitive neutrality, as well as to see the limitations of the current competition framework, namely the Competition Act of 2010. The team at Ideas undertook a study to look into these sectors. These sectors were selected because they do represent segments of the economy where all key corporate actors are active participants. So you have the GLCs, you have the large business groups, the MNCs, the small and medium enterprises, as well as the multinationals. So these are the traditional, it's a good mix of traditional and non-traditional sectors where GLCs have a significant presence. In comparison to these sectors, we did do some form of assessment on how competition is covered or governed by the Competition Act for these 5 different subsectors. So to understand, again, the relationship of the stakeholders on the ground, we also did a mapping exercise, which I will share with you later on. And we found that there's no specific structure or relations within sectors. And this would highlight that there are a variety of forms of intervention and also interaction leading to different levels of competition, as well as distinctive forms of GLC's participation within the economy. So before we go ahead and to look at the findings, I think it's worth to note the definition of competitive neutrality and why it's important for competitive neutrality to prevail in the modern trading world. So according to the OECD, a state in which all stakeholders, including businesses and SOEs, can compete on a level of playing field. This is where we achieve competitive neutrality. So this is where players use resources optimally in a healthy and competitive market to deliver goods and services at competitive prices for consumers and households on the ground. So this is also very important for Malaysia as we embark to sign on and also to ratify various international free trade agreements. Competitive neutrality clauses will be included in the SOE chapters of these new generation of FTAs, like the original TPP and the CPTPP, to ensure that we do have a level playing field for all of the players in a given sector. So again, this is very much in line with the OECD Council recommendations that are in line with the agreement that we have signed on to and ratified. So even though Malaysia is not a member of the OECD, it aspires to adopt international standards on trade and also investment-related activities. So just a bit of a background on competitive neutrality. The OECD Council adopted a recommendation establishing a set of principles to ensure that government's actions are competitively neutral and that all enterprises face a level playing field, irrespective of factors such as the enterprise's ownership, location, or its legal form. So it also recommends adopting and maintaining neutral market rules so that adhering governments ensure that the legal framework is neutral and that competition is not unduly prevented, restricted, or even distorted. So I'll talk a bit about the background to the Competition Act, but my colleague Raj will also be explaining more on that. So as was mentioned before, the Competition Act was just introduced in 2010, and here it outlines that it prohibits anti-competitive agreements and the abuse of a dominant position in the market. So the Act has been enforced since 2012. And we do have the Competition Act 2010 and also the Competition Commission Act 2010 in place as well. So here we do see that even though there is a Competition Act governing competition in Malaysia, there are exclusions, and these exclusions are on the Communications and Multimedia Act of 1998, these sectors, the energy sector, the Petroleum Development Act 1974, and the Petroleum Regulations 1974, as well as the Aviation Commission Act of 2015. So there are exemptions to the governance of the Competition Act in itself. So just as a bit of a background for Malaysia, this was introduced again in 2010, and then the regulator would be MyCC. It constituted one part of a series of reforms by then Prime Minister Najib Razak. So the principal aim of these reforms was to create an economic environment that would instill investors' confidence into investing in Malaysia. So on that note, again, the objective of the act was to encourage economic growth through competition and also to protect the interests of the consumers, with an added legislative purpose to prohibit anti-competitive conduct. Looking at the Competition Act and looking at the sectors that we've observed, we did find that it is adequate, somewhat adequate to regulate anti-competitive behaviors within different sectors in the country, but it must be enhanced and also upgraded. So currently the Act prohibits the abuse of dominant positions. However, it must also look into the absence of the clauses on provisions on mergers and acquisitions, for example. The exemption of state activities undertaken are currently inclusive of directly or indirectly in the exercise of government authority. Again, it has exemptions for different sectors, and because of such exemptions, it does create a dual system of monitoring of not just one regulator, but possibly two in a given sector itself. I will now share with you the mapping of the stakeholders within a given sector and how these stakeholders come into play with one another and how this would impact competition. So looking at the banking sector, it's just like the telecommunications sector, as well as the traditional energy sectors. It is very much dominated by the GLCs. So further consolidation is expected in banking, though competition is expected to increase when digital banking licenses have been issued in its entirety. So for your information, the Minister of Finance has control over major GLCs via regulation and also via the state's power to issue licenses for finance-related businesses. So the GLICs here under the jurisdiction of MOF have a majority ownership of bank-based GLCs. In the governing institutional framework created by the government, we did see that safeguards have been built into the system to ensure checks and balances exist. Interestingly, in spite of concerns about accountability and also transparent governance, there is vibrant and much competition in this sector, as well as the subsectors between the domestic and also foreign enterprises. There is evidence of competition between bank-based GLCs, as well as between themselves and also privately owned financial institutions. So this suggests that some level of competitive neutrality prevails, though further review is required of joint ventures to determine where the decision-making process resides and its control. And So of importance too here is if private enterprises that receive government rents act independently, or if they are compelled to follow the guidelines or the orders of certain entities, this is going to impact on competition and competitive neutrality. So in the past, the GLC's banks have undergone mergers with private banks out of necessity. So the case of Southern Bank, there have been takeovers such as the acquisition of RHB Bank by EPF. So here we did see that the lack of transparency in these mergers and acquisitions will impact how well the sector is regulated and how fair competition can prevail. So we did also see that a well-structured governing institutional frameworks have been created to regulate the market with adequate legislations overseen by the Central Bank of Malaysia as well as the Securities Commission. With such laws and institutions in place, this creates the idea of a well-functioning level playing field that promotes competition. However, we did see that transparent and accountable governance is needed if the government hopes to develop the digital banking sector, which is lagging behind other countries within the region. Now let's take a look at the higher education sector. So here we see that there is deep competition in the higher education sector, with the presence of a huge number of public and also private universities, as well as foreign branch campuses and tertiary institutions. These tertiary institutions include government-linked universities as well. And from this cytoscape, we do see that there's a dual ownership system within the sector, as the government runs the public and private universities, while the major publicly listed GLCs owned government-linked universities as well. So we do see that these public higher education institutions and the private higher education institutions receive funding from different sources. The public higher education institutions depend heavily on the government for funding. So while the public higher education institution, but not their JLC specifically, are under the jurisdiction of the Ministry of Higher Education, they are also similarly complex and varied ownership patterns in place among these GLC-based universities that function as private enterprises. So let's take a look at the energy sector. So on this slide, we can see the ownership patterns among traditional fossil fuel power producers in Peninsular Malaysia, which account for over 70% of installed capacity. So here we see that the TNB is the largest player. TNB is also the single buyer and also grid system operator. However, we can see that TNB is also present as a power producer through a network of subsidiaries. So in total, TNB accounts for over half of installed capacity in Peninsular Malaysia. There are then some key private players as well. YTL was the first IPP to be licensed, but the largest player is MMC Corp and its subsidiaries, which is the largest IPP entity here. We should also note that there is presence of foreign players within the sector. The acquisition of EDRA Power Holdings by the Chinese state-owned enterprises is the only case of the government permitting a foreign-controlled IPP holding within the country. The acquisition was part of a range of Malaysian-Chinese cooperation project under the BRI. So the prominence of the MMC Corporation and the China Central Nuclear Power Corporation underlines the entry for private players into the power market, which can be highly political indeed. Another traditional sector that we can see the presence of GLCs would be the telecommunication sector. We can see that despite liberalization efforts and also competition, GLCs retain a high presence or a significant presence in the market. Of course, we see Telecom Malaysia is very important here, but both Time and also Axiata are also state-controlled through Hazana and also Maxis and DG, having significant shareholders among other GLICs. So this underlines the fact that a high level of government ownership does not preclude a high level of competition. It doesn't necessarily mean that. So foreign entities are also important in the industry. Within this industry, we see other players, big and small, like DG and also U Mobile. So here is where competition is getting more vibrant in relatively new and relatively non-traditional sectors. Here we see that even though GLCs are present in the information technology sector, the presence of non-GLCs entities are also very encouraging compared to the telecommunication subsector within the ICT sector. It was also found that there are telecommunication-based GLCs that have branched out into both the ICT and the fintech sectors. So from the figure here, we found that at the center, there are ministries that are in charge of regulating and developing the sectors. Nevertheless, we also found that these regulators have also created statutory bodies that are in charge of developing and also regulating local firms within the sector. The ministries have created GLIFs such as the Social Security Organization, SOCSO, as well as the Hazana National Berhad, among others. So these bodies then create other subsidiaries as an extension, such as Time.com and Axiata Berhad, that must compete with both local and international players. What is interesting about this sector is that the latest data available highlights that there are more than 700 firms. So this would, in this sector, this would include local tech startups, GLCs, MNCs such as Microsoft, Intel, IBM, and also Dell Technologies. So these multinationals have been in Malaysia for more than 2 decades and are active in developing this sector through technology transfer and also training of local talents. So the last sector that we looked into was fintech, also a very non-traditional sector in terms of GLC's presence. And here it's the same, the presence of non-GLCs is also very encouraging compared to other traditional sectors like energy and telecommunication. And here we did see that for the fintech sectors, we see players from the GLC players from the ICT sector branching out into fintech and vice versa. So again, we found at the center there are ministries that are in charge of regulating and developing the sector, but we do see that these regulators have also created statutory bodies that are in charge of developing the sector itself. The ministries in extensions have created other types of firms like Amanah Raya Berhad and Urus Harta Jamaah Sendirian Berhad, among others. So these bodies go again to create other subsidiaries as their extensions, and this would include the CIMB Group holding Berhad and also Axiata Berhad that must also compete with local and international players alike. So in the fintech sector, we see that entities are either for the GLCs they are either wholly or partially government owned. So just like the ICT sector, the ownership of fintech companies is both by federal and also state agencies. For example, Sarawak, Pay Global, and Digital Penang are examples of 2 state-owned enterprises used as vehicles to penetrate into this sector. Another interesting enterprise is the IMSME, wholly owned by Credit Guarantee Corporation Malaysia. So Bank Negara, which regulates e-commerce activities, has about 80% stake in this company. So another important player is Boost Credit, owned by Axiata Digital Company Capital. So during the rollout of the e-wallet initiative in 2019, Boost was given the lead for this initiative, given its well-developed platform and coverage of the market. So other platforms such as GrabPay is also within this sector. The other enterprises are also partially owned by the government with up to about 28% of equity interest. These companies are important in the market as they have captured substantial market share. I know it's quite overwhelming because it's about 5 sectors, but these are the key findings that we did see. We tried to map out the level of competition and also the GLC's presence in key sectors and subsectors that we looked into. So as you can see here, the level of competition is very different. Looking at the nature of the sector itself. So what is important to note here is that the mapping of these sectors indicate that GLCs have a dominant presence in the economy. However, extensive GLC presence does not mean limited competition. So GLCs compete and sometimes cooperate with different business entities or business groups, SMEs, and also multinationals. And here we see that the intensity of competition is very different between sectors as well as within sectors. As mentioned before, the banking, the telco, and also the traditional energy sectors are very much dominated or have strong GLC's presence. Further consolidation is also expected in banking, though competition will increase with the issuance of digital banking licenses have been completed. So we do see that there is intense competition in solar-based industry through mergers. This may occur in this sector as well. Competition in the telco sector is complicated, and my colleague Raj will also maybe share his experience working on this, and especially following the introduction of a GLC like Digital National DNB that has been mandated to deliver the 5th generation mobile network. So again, there is deep competition in the higher education sector with the presence of a huge number of public and also private universities, as well as foreign branch campuses and also tertiary institutions. So we see here a dual ownership system has been created as the government runs both public and private universities. As mentioned before, in the new sectors such as the renewable energy, ICT, and fintech, GLC presence is not extensive. And this is where know-how and also expertise is very much needed. And since those know-how and expertise have not been developed within the economy, then competition will flourish, allowing private firms, even SMEs, to thrive here. So we do see that mobility restrictions imposed during the pandemic have further encouraged competition within these sectors. We were only able to capture a portion of the players, but there's more data coming in, and this sector in itself will grow exponentially in the coming years to come. So the real challenges here lies in competitive neutrality. Even though there is competition, even though some form of competitive neutrality is evident in some of the sectors here, but the challenges really lie in 3 different buckets. One is on the public procurement, one is on regulation, and one is on financing. On public procurement, in the areas of public procurement, GLCs may be given preferential treatment in delivering certain goods and services due to their connection. In terms of regulation, there is a dual regulatory body system that acts as regulators, where one is given the specific task on regulating anti-competitive behavior, while the other is in charge of developing the sector in itself. So we see here in fintech sectors and also ICT sectors as well. For financing, GLCs would have access to loan guarantees, and this creates an additional barriers for entry for others that do not have the same access to financing. So going forward, I think it's important to note that the mapping exercise have shown that there's high levels of connectivity between all of the stakeholders or players within a certain sector. We also found that there's different patterns of shareholdings interaction between GLCs, SMEs, multinationals, and also large business groups. We do see that the structure of competition of each sector and subsectors varies considerably, indicating different forms of intervention and interactions by the GLCs. With this, we do think that regulators may need to review complexities of these very interlocking relations, especially when it impacts business sentiments on the ground when it in view of attracting FDIs. So regulators, again, may need to review the complexity of the roles and how it interplays with one another in these varied interlocking relations, and how this will impact not just competition and competitive neutrality, but also clarity in policy direction and policy areas of implementation. So this will be our last slide. So again, the recommendations include expediting amendments of the Competition Act itself. So we need to introduce anti-merger provisions and greater accountability mechanisms during states' exercise of its authority. We need to provide wider framework for competitive neutrality. As mentioned, key areas to work on are the public procurement, licensing, and also financing. We need regulators to also regularly assess how GLCs function in each sector and subsectors to ensure that competition is not undermined. And also, in terms of competition, we need to introduce policies to strengthen the competition network and enforce principles of competitive neutrality that is aligned to the CPTPP agreement that we have ratified and entered into force very recently. So with this, I will end my presentation and I will pass the floor to Julia. Thank you.
Thank you so much, Juita, for your presentation. That was really great. And I would now like to invite our second speaker, Mr. Nadaraj Naraj Sargunaraj, partner at Zayed Ibrahim & Co., to give his presentation on anti-competitive behaviors and its remedies. Over to you, Raj.
Thank you so much, Julia. Thank you so much, BMCC and Ideas, for inviting me for this wonderful session, actually. It's going to be a tough task to follow on from what Dr. Juita's comprehensive presentation earlier, but I'll try my best. I also am conscious of time. I know I'm standing between, for those of you in Malaysia, the after-hour traffic, and also for some of you, happy hour. Anyway, let me jump straight into this. So there are three key points that I would be taking on from Dr. Juita's presentation and talking to you about some of the remedies that could be looked at in addressing some of the issues that was presented earlier. So the point number one is state aid regulation and prohibition. Point number two, single regulator or sector regulators, which is the better approach. And number three, the courts being a key stakeholder in coming to competitive neutrality. So on point number one, just a bit of a background on the Malaysian Competition Act. It generally prohibits two key prohibitions. Number one, anti-competitive agreements. These are, for example, cartel conduct, price fixing, sharing of markets, those sort of things. When it comes to GLCs, the more relevant prohibition would be on the abuse of a dominant position. So being dominant by itself is not a prohibition, it's the abuse of it that is anti-competitive. Now, there is another vertical in competition law, say in EU, where it prohibits state aid for where the government cannot provide certain aids that would distort competition in the market. Now, there is no such law in Malaysia, and in fact, I'm not aware of this law being present in, say, even in Singapore, more mature competition law jurisdictions in ASEAN. So just a bit of a background on this prohibition. Now, the EU treaty prohibits aid granted to member states to state resources which distorts competition. An aid is selective and it affects competition between the beneficiary firm and its competitors. Now, 4 key characteristics on this prohibition is granted by the state, or it could be through state resources. So Dr. Juita was mentioning to you earlier that how GLCs are actually acting on instructions or acting as proxy to the government as they invest into the economy. So would that be caught under this state aid regulation? That's a question to be asked. Now, there could be favors by conferring advantage to certain undertakings or production of goods, distorts competition, where it strengthens the recipient to the disadvantage of the competitors in the market. And in the EU context, it affects trade between EU member states. Now, the classic form of state aid is direct subsidies, but it also can come in other forms, as you would see in the bullet points in the slide. Tax exemptions is very popular, though I've been observing some cases in the EU where the EU Commission has been losing some cases in court on appeal, where tax exemptions have been granted as a form of state aid. The courts did not agree to that and overturned fines that were imposed on, say, companies like Apple and Amazon. But here are some of the examples of state aid. And one case in 1997 is in France, where France restructured EDF balance sheet and increased its capital. And as part of that restructuring, EDF was granted tax break of euro 889 million on its corporate tax. Now, note here that EDF is a wholly owned state-owned entity. And this was part of a wider effort to clarify the legal and financial regime under which EDF operated. So this was a form of state aid. So the question here is, would such a regulation benefit Malaysia in the sense that it would put in some check and balances in terms of the presence of GLC in the broader economy itself? Now, well, it must be noted that state aid has its benefits, and we saw this during the pandemic. So I would not think that an absolute prohibition on state aid should be enacted into law, but perhaps regulating state aid may provide more clarity for businesses in the economy. Point number 2 is a single regulator or sector regulators. Just a bit of background. So Dr. Juita was explaining that you have the umbrella law, which applies to all sectors, which is the Competition Act, and that is regulated by MyCC. And you do also have sector regulators, which are carved out from the Competition Act. Why is this so? There's a bit of historical reason for this. Competition law was first present in the communications and multimedia sector in 1998. So that was the only law that had competition provisions at the time. So in a sense, it had the power of incumbency. And later on in the Energy Commission, so in relation to the energy sector, only after in 2010 did the Competition Act came into force, and that was regulated by MyCC. But as part of it, because the communications regulator and the energy regulator already had competition experience, they were carved out. So MyCC was the general regulator, but these two sectors were carved out. MyCC then entered into a memorandum of understanding with the central bank, where both regulators were to work together in enforcing competition laws in the banking and financial services sector. Now, in 2015, the government then decided to carve out MAVCOM, which is the aviation services regulator, and that was how MyCC came into force and how these sectors were carved out from the umbrella law itself. When we say carve out, it doesn't mean that these sectors do not have competition law. In fact, all these laws actually have competition. The only difference is that it is not regulated under MyCC, but their own sector regulators. So this is how it looks now. You have the Competition Act, which is enforced by MyCC. You have all these other laws in the table below that is governed by sector regulators. Now, is this good or bad? Well, in the next few slides, I will explain to you how the other jurisdictions look at it. But there are pros and cons to having a single regulator and or sector regulator. And I'll draw in this experience that I had in a recent merger between two largest telcos in Malaysia, Digi and Celcom. When we were working on this merger, the regulator itself was not only looking at competition when assessing the merger application, but it was also addressing pain points in the industry. For example, the regulator actually wanted a strong telco player to compete with the other incumbents in the market, and also looking at the 5G rollout, which would require a lot of capex. Now, a strong telco would be able to look into this and accelerate the 5G rollout in the future. So sector regulators do have its benefits, but at the same time, you want to have a very competition policy across all industries, which means MyCC's role becomes very important as well. In other jurisdictions, you will see in the UK, you have the CMA, you have the European Commission. In the US, you have DOJ and FTC. All these are actually central competition regulators. That being said, in these jurisdictions, these central competition regulators actually work very closely with sector regulators to enforce competition law. Similarly, in Singapore, the CCCS, which was only previously looking at competition, now assumed the consumer protection role as well. So while the CCCS is the central regulator for competition matters, it does work very closely with the communications regulator in Singapore to enforce competition in all sectors. So the question of whether you should have one regulator doing it or having secondary regulators is not an easy question to answer, and there are pros and cons in both options. The last point here is the courts being the key stakeholders. While we always look back at the regulators, the enforcers to ensure the competition in the market, we tend to forget that the courts is actually a key stakeholder as well. Now, one important point in the Competition Act is that the Competition Act allows a private litigant to go directly to a court to file a claim against any enterprise that is infringing the Act. I'll explain to you what an enterprise means in the next slide. Now, the private litigant must have suffered some form of a loss or damage directly as a result of an infringement. Now, the action can be brought regardless of whether the private litigant dealt directly or indirectly with the enterprise. So while you could have, say, a competitor who has suffered losses because of anti-competitive practices by a dominant enterprise in the market, you could also have associations like the Consumer Association filing a claim. While they were not directly affected, the Act allows a claim to be brought where they are indirectly affected. So this is a very useful tool, because now you would have private litigants going directly to the courts to enforce competition law breaches. Now, I was telling you, I referred to the term enterprise in my earlier slide. An enterprise is a wide concept, and it applies to an entity carrying on commercial activities, regardless of its legal status or the way it is financed. With this wide definition, it covers GLCs that are carrying on commercial activities in the market. So while it may be a government-linked or government-owned entity, it is an enterprise. And if it is an enterprise, then a private litigant can enforce competition law in court against that particular GLC. Now, while I'm not advocating for private litigants to take all GLCs to court, but it is a check and balance in terms of how they conduct themselves in the market. If they have acted anti-competitive, then it is open to industry to actually seek remedies in court. This is very useful if, let's say, MyCC does not act upon a complaint, or any of the regulator does not act against or on the complaint, right? You still have the recourse to court. Now, I also wanted to, while I have said this, the regulator, MyCC, has been very active in terms of enforcement, and they have acted against GLC. When Malaysia Airlines was owned by Khazanah, they did investigate Malaysia Airlines in a alleged cartel conduct with AirAsia, its direct competitor at the time, and fines were imposed. So it shows that the regulator would go after GLCs where there is anti-competitive conduct. Actually, that was the last of my slides. I will, yes, end my session here. Thank you.
Thank you very much, Raj and Juita, for your great presentations. You're very insightful in presentations. I would now like to open the floor for our Q&A session, and we will be reading out some questions from our attendees. So we don't have much time. Unfortunately, I think we may be cutting our Q&A session a little bit short, but that's okay. I think we'll still be able to answer the questions that we've got. So my first question is for Dr. Juita. So how is competition like in the sectors observed, given the presence of all players in a given sector?
Thank you, Julia. So I think it's important here to note that from our mapping exercise that even though GLCs do have a significant presence in all of the subsectors that we've looked into, we did highlight a very important finding, which is extensive GLC presence does not mean that it would lead to limited competition. So here we do see that in the traditional sectors like banking, telco, and the traditional energy sectors where they're largely dominated by GLCs, they do compete with one another, but in less traditional sectors like ICT and also fintech, because of lack of knowledge and lack of expertise to date on the ground, more players are coming in from within Malaysia and outside of Malaysia, boosting the growth of these sectors in a very healthy and competitive way. Yeah.
Thank you, Dr. Juita. So for you, Raj, I've got one question too. Do you see many cases where an individual person or company files a claim in court for a competition law breach, or do they prefer to complain to MyCC for action to be taken?
Thanks, Julia. Yeah, not in Malaysia. You don't see a lot of private litigants filing claims in court, but you do see this very popular in foreign countries like the United States, for example. There is a reason for this, because the cost of gathering evidence and proving your matter in court, it can be prohibitive at times, right? Because as participants may know, competition law involves a lot of economics, and you would have to present as evidence a lot of economic arguments to prove that there has been anti-competitive conduct. Now, if you have a free method to just complain to MyCC and hopefully they take it up, then why not? So yes, the answer to the question is not very popular yet in Malaysia, but hopefully if it gains popularity, then there will be a second way of enforcing competition law apart from relying on the regulators.
Thank you so much. Okay, I think that is all we've got time for today, but thank you both so much for your presentations. I would like to now pass the floor to Dr. Tricia Yeo, CEO of the Institute for Democracy and Economic Affairs, to give her closing remarks. Over to you, Dr. Tricia.
Thank you so much, Julia. So thank you everyone who have attended and stayed throughout this webinar. We apologize that we haven't had enough time for everyone to ask their questions, but thank you for staying anyway. So firstly, I'd like to say thank you to David Wallace, the Deputy High Commissioner from the British High Commission, to Ms. Jennifer Lopez, the CEO of the British Malaysia Chamber of Commerce, and of course to Adeline Teo from the British High Commission as well, who has worked so hard in putting all of this together, and also to the British High Commission for sponsoring and supporting ideas for the project that we have been working on. This project actually concluded some time ago, and we just would like to thank the British High Commission for the support that was provided to us. So I think all of you have heard already that while competition laws do exist in Malaysia in the form of the Competition Act 2010, and while there has been recognition of competition laws, encouraging businesses and trade in the country. We also recognize that there are some limitations, and of course, given the project that we have concluded, we did this mapping of all the GLCs in the various different sectors and how they compete. Excuse me, I'm having a slight flu. Within the local framework. We know at the outset, and this was said at the very beginning as well, that competition is good because it allows competition among the different industries to lower prices, to increase quality for consumers, ultimately to increase business opportunities and to increase trade between different countries. Of course, we hope that these opportunities will increase for not just Malaysia and the UK, but for other countries as well. But in order for all of these to take place, competitive neutrality is crucial. And we would like to see that happening much more in a country and a context like Malaysia. So I think what you have heard from my colleague, Dr. Juita's presentation, is that the sectors that we mapped out, that there is no clear and consistent pattern and trend. That's what she's demonstrated through the mapping exercise. But that has been really useful for us to understand and do a deep dive. In fact, this has also provided ideas, the impetus and the opportunity to raise more funding, in fact, and ideas will be embarking on yet another project this year where we'll be doing a sectoral deep dive following from the first exercise and what you've already seen. So we hope to be able to be ready with those findings and recommendations to the government, how to improve competitive neutrality even more towards the end of the year. So I hope that all of you will follow us, and we should be in a position to launch those papers towards the end of this year. So I'll keep it short, but I just once again would like to thank everyone for being here today and spending your afternoon on this Thursday afternoon with us at Ideas. Ideas, for those of you who are not familiar, is an independent think tank based here in Kuala Lumpur. We don't just look at the areas of economics and business and trade, but we also look in a whole range of other areas, doing policy research and advocacy on social policy, economics and business, public finance and democracy and governance. And we regularly organize talks like these, but also roundtable discussions, closed door, focus groups to gauge the sentiment from various different stakeholders. We see ourselves as a cross-partisan platform working with the civil society, private sector, and government crucially as well. So we look forward to engaging all of you in the future, and please do follow us online. We have a lot of activities coming up, and we have the major conference on the Malaysia Outlook conference taking place on the 9th of March. So thank you to all of you, and of course to our speakers, Raj from Zico as well. Thank you for being here with us, and especially to you, Jennifer Lopez. Thank you so much for your team in putting all of this together, and of course, it's Julia. So I will end there and look forward to engaging with all the participants, hopefully in the future, for our second phase of this project. And I pass the time back to Julia.
Thank you so much, Dr. Trisha, and just thank you to everybody who has made this event possible. Just to echo what Dr. Trisha has said, we have come to the end of the webinar today, and we would really like to extend our warmest gratitude to all our esteemed speakers and our participants for attending today and for staying with us. We hope that the webinar today has provided everyone with insights on enhancing international trade opportunities in Malaysia, as we intended to do. And as we hope that if you have any further questions, please feel free to reach out to us as well. We welcome further questions, that maybe some of them that we weren't able to answer today with the limits of time. But yeah, thank you everyone, and have a great evening ahead.